Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Alrighty, we're back with Jeff Roberts. Jeff, it's been a busy month for you, and actually really excited to talk about this today. You just got back from a Supreme Court oral argument, so we're going to crack that one open today and let the listeners kind of know what all that's about and how that all works.
Yes, I did. I had an oral argument earlier this month on the 21st of this month, and I did it by Zoom, so I didn't have to travel to Frankfurt for the oral argument, and that took place, and so it's been a lot of time in preparation for that argument.
And with the Supreme Court, it's a little different because it's not what we might see on TV like CSI or something like that. The Supreme Court hearing structurally is different, right? I mean, you've got multiple justices there to whom you're speaking. They typically ask most of the questions, I would imagine. It's not the quote theater you might see in a family law situation or something like that, right?
Right. It's not to a jury. It was before the Kentucky Supreme Court. There were 7 justices in Kentucky at the Supreme Court, and so they all sit on the bench, and you direct your argument to them. They can interrupt you and ask any questions that they have. You've got a very limited amount of time, 15 minutes total, to present your case. Both sides present their case. I was the one who made the appeal, so I also was able to do a rebuttal to the other side's argument, but my total time was 15 minutes, so it was 12 minutes to do my initial presentation, 3 minutes for rebuttal, for a total of 15 minutes in that situation.
It's amazing. At the highest court in the state, that's the time limit, right? Once you get there, but there's a lot that goes into getting a case to that level, to oral arguments. I mean, there are briefs that are written. You want to kind of walk us through that process? I mean, cases just don't automatically go to the Kentucky Supreme Court.
No, they do not. This is the case that I had there. It was a constitutional question that was being presented, but it was in regard to a workers' compensation claim. So the case was presented first to an administrative law judge, because workers' compensation cases are an administrative process to start with before they get into what's called the true court system. So the administrative law judge made the decision, ruled in my favor on the issue that's currently presented in the case. In fact, the statute that I'm trying to have declared unconstitutional hadn't even been proposed as a bill in Kentucky at the time the administrative law judge made his decision. The Workers' Compensation Board is the first appellate level, is the only appellate level in the workers' compensation process, in the administrative process. So the case was appealed by the defendants to the Workers' Compensation Board. They again ruled in my favor because the statute had not, even though it had been passed at that point, it had not yet taken effect there. And then the defendant appealed it again to the Court of Appeals, which was the true first court that we were in the case. The Court of Appeals, the statute had become effective at that point, and at least is the statute says it's to be applied retroactively to all cases that were pending at the time the statute become effective.
So as long as these other cases had been filed, whatever happens in your case would affect all of those cases that are pending? Is that what it means in that regard?
Right. The statute become effective July 14, 2018, and what it said in that statute was that any cases filed before, any work injuries that occurred before July 14, 2018, this statute will apply to those if they have not been fully and finally adjudicated by the court system or by the administrative process.
So if a decision in that case had not been made, it's still live ball.
It's still a live ball,
okay.
Or even if like in my case where the judge had already decided it, and it was appealed basically to keep it alive until the statute became effective. Then at least the statute by its language would apply to all of those cases. One of my arguments is applying that I was arguing to the Supreme Court was applying that statute retroactively to all of these other cases. My client's case and all the other cases that had not been final was unconstitutional, a violation of due process, and a variety of other constitutional challenges that I had presented in that situation. And normally in Kentucky, in Kentucky, whenever you are injured on the job, what Kentucky law says is the law in effect on the date of injury controls your and the employer's rights under the workers' compensation system. So, the way the case law is, in my view on the matter, is that the legislature can't not change the law to make it more favorable to the employer after the injury has occurred. And likewise, they can't make it more favorable to the employee after the injury had occurred. So my argument is essentially that they limited my client's benefits, took money away out of my client's pocket from what the judge had awarded to my client, and I don't think they can constitutionally do that. I hope the Supreme Court agrees with me in that regard. And but if it had worked the other way, I'm sure the other side would have been arguing, hey, you can't give her more money than what she would have been entitled to at the time of her injury by changing the law after the fact. So, and it would apply if the Supreme Court agrees with me. It would cut both ways because there are some things that may be more favorable to the employer in some other aspects.
Right. So ultimately, among other things, one of the key issues here is the constitutionality of this retroactive measure in the statute.
Correct.
Okay.
The Constitution.
You can't reach back and do this.
Exactly.
Yeah.
You can't reach back. You can't change. You can't change the law after the fact and then say, well, it applies to these cases.
Right.
And there's case law that supports me in that argument. Obviously, otherwise I wouldn't be making that argument. But it's just it's convincing 4 of the 7 justices. That my view on it's right, and that the Attorney General and the defense attorney's views are wrong.
And it's 4 because that's the majority, but there's a little history. Some people have shown their cards in this particular case. You want to kind of get into that a little bit?
Well, on the retroactivity, they've not shown their cards, but
and we're talking about the justices and how they may rule.
The justices, yes. I understood going in, at least on some of my arguments, that I do have a long road to hoe, so to speak, using country terms, which is what I normally use. But the statute that the 2018 statute replaced had been held unconstitutional back in 2017 when the Supreme Court held that statute unconstitutional. And the current law that is being applied retroactively to my client would actually be a little bit better than what the 1996 law that was held unconstitutional in 2017 said as far as benefits to the injured worker. From that standpoint, it had been held unconstitutional before my client's case was decided by an administrative law judge in that standpoint. So 3 of the judges dissented in that 2017 case and said that the statute was constitutional.
So you're assuming they'll hold that opinion,
yes,
as they evaluate your argument.
Those 3 justices are still on the Supreme Court, and my expectation is, while I tried to expound on why I thought they were the reasoning, I didn't say you were wrong in your dissent. I'm smarter than to do that, but I did point out some of the arguments they made in the dissent, why they did not apply in this situation, or tried to explain that to some extent without saying y'all were wrong. But those 3 justices are still on the court. Unfortunately, only one of the 4 that found the statute unconstitutional is still on the court. My expectation is as far as the 2018 statute being applied to injuries occurring on or after July 14, 2018, I think those 3 justices that said the old statute was constitutional will likely stay the same and say the new statute is constitutional as applied to injuries, at least in the future, from the day that it become law and into the future. So I have to convince the other three justices, the three new justices, that it's unconstitutional. And I hope, frankly, I get all seven of them to say applying it retroactively is unconstitutional.
Yeah, that would be very clean if you could do that.
If I could do that, and then that would, because that would resolve a lot of issues. My case has been litigated for quite a long time. I've got another case actually at the Supreme Court that is kind of put on hold until they decide this case that I just argued. From that, and I know a lot of other attorneys who have, and a lot of injured workers who are in the same boat as my current client is, in that their injury occurred before the new law become effective, but it was applied to their case to take money out of their pockets. And so it's, and essentially whenever the law was proposed and passed in early 2018, and if I was a defense attorney, I would have done it too. I'm not faulting any defense attorney for appealing these cases to keep the cases alive, but they all did that to keep the cases alive so that the new law would apply, and obviously their client would save money, and it cost the injured workers money from that perspective. So essentially every case that would have been decided that this law applies to anyway, that would have been decided sometime in late 2017, 2018, when this case came about, when this statute was first being bandied about, those cases have stayed alive just until the Supreme Court finally tells us, yes, they can do that, or no, they can't do that.
And you got to be one of the very few attorneys who's actually arguing that point live in front, well, not in front, it's be Zoom, but directly to the justices as to the merits of that claim.
Correct. I was the only attorney arguing that it should be held unconstitutional.
Yeah.
I had because the Attorney General's job is to defend the statutes that are passed by the legislature from that standpoint. So there was one of the, not Attorney General Daniel Cameron wasn't the one arguing it. One of his assistants is the one who argued it, but they were arguing that the statute should be held constitutional as it is written, and then the attorney who represented the employer all the way through the process was arguing that the statute should be applied as written, and that it was constitutional. So I'm the only one arguing against that.
Right. So let's get into a little technical jargon here. You had mentioned that you had another case up there right now, and that was put on hold. And I guess that term is called it's placed in abeyance. Is that what happens?
Yes.
And really, what is that used for? Why does that actually happen? I think you just explained it more or less, but that's
a case is placed in abeyance. A case can be placed in abeyance for a variety of reasons. These appeals have been placed in abeyance because of there's essentially the Supreme Court in Kentucky will be the final decision maker on these cases. And so cases that are at the Workers' Compensation Board, and I have one there, cases at the Court of Appeals, cases, and even other cases at the Supreme Court that have the same issue, constitutional issue in them over this statute. What the courts do is say, we know this is going to be decided by the Supreme Court. In this case has already been briefed to the Supreme Court. It's before all these other cases. So we're going to put these other cases on hold and wait for the Supreme Court to make the decision. It's kind of a waste of judicial resources for the Workers' Compensation Board to say, we can't declare this statute unconstitutional, so we got to apply it as written. For the Court of Appeals to address the issue, knowing that whatever they say in the thing is going to be, may or may not be undone by the Supreme Court, depending on if they agree, if their reasoning is the same as the Supreme Court reasoning in the case. So instead of wasting their efforts, they put these cases on hold, waiting for the Supreme Court to decide this case, the case that I have there at this point. And then if it declares the statute unconstitutional or unconstitutional being applied retroactively, then the courts would essentially then apply that new Supreme Court law precedent to all the pending cases, and instead of them deciding it and then making the attorneys file the appeals to keep the case going. It just says, okay, we're not going to waste, we're going to not going to make people waste a whole lot of effort. We're just going to put it on hold, wait for the Supreme Court decision, and then we'll pick it back up. And it allows the court then to go on to other cases, because whatever, if the board just said something in the case right now, the Court of Appeals said something in the case, it's going to get appealed to the next higher level. And so it's not going to resolve the case whatsoever. So the courts should basically put these cases, and we're going to set them on the side of the desk until we hear what the Supreme Court says.
Yep.
And the cases that our decisions are actually going to mean something right now, let's go ahead and decide those cases.
And I think what's interesting about all of this is that once again, this is you before the Kentucky Supreme Court. And, you always say, small town service, big city results. And here you are down here in Murray, Calloway County, and you're the guy, that's going up once again to Frankfort in front of the Supreme Court. And that's just, that's a testament to your skill and just the reputation. And it's, a lot of your colleagues recognize that about you. So congratulations on that. 27 years worth.
Yeah, I appreciate that. And I have been in front of the Supreme Court on cases and argued them in briefs and orally to the Supreme Court in the past. This one was, I was somewhat surprised at the way the Supreme Court did this case. My case that I presented this issue in over the constitutionality of this statute, I know there were two cases that were before the Supreme Court sooner that got to the Supreme Court and were briefed before my case was. I learned actually later on that I think there's at least two more cases that were before my case at the Supreme Court. Two of the attorneys on the cases, the first two cases that got the Supreme Court, I know them, the attorneys who represent the injured workers, I know them, they're friends of mine, and we had talked about that we had these three cases pending up there. They've raised an issue a little different than the issue that I had raised to some extent, but we actually filed a joint motion, all three of us, to consolidate all three cases before the Supreme Court to have the court basically decide all three cases at one time.
And what would be the advantage of that?
It would allow the court to address all the different arguments that had been made, the arguments that they had made, the arguments that I had made. Some overlap, some didn't overlap from that standpoint, but it would allow all three of the cases the court to address all the issues that had been presented. Actually, none of the defense attorneys involved in the case, nor the Attorney General, objected to the cases being consolidated, and in fact said that they thought the cases should be consolidated at the Supreme Court. In the Supreme Court, instead of consolidating the cases, which frankly I would have kind of liked, because that would have been me and then two other attorneys arguing on behalf that this statute is unconstitutional. But the Supreme Court looked at it, and even though mine was the fifth case actually to be up in front of them, they didn't tell me why, and I don't know specifically why, but they said we're going to put these two earlier cases in abeyance, all the other cases in abeyance, and we're going to take the case that I have before them, and we're going to use this case to decide it. Now, hopefully.
So you don't chalk that up to your legal razzmatazz, or probably not?
I don't chalk it up to that from that standpoint. Now, part of me would like to think that, but I don't know that that's played a role in it at all. And it may be that they looked at it and thought this was the best case. And I think my case, especially from the standpoint of the retroactivity, probably had that addressed better. And in some of the other cases may have had some issues as to whether the issues were properly preserved or something of that nature. And instead of addressing that, they're going to address it in my case. I don't know exactly why. They didn't tell me why.
Sure.
But I'm glad I got the opportunity to argue once again to the Supreme Court.
That's outstanding. Now sticking with the legal focus here, obviously, you mentioned some of these cases that have already been briefed, obviously, to the Supreme Court. And a brief is a legal argument. It's written down. It's not done in front of the judge. It's a document that you draft with a lot of research and everything, trying to support your argument or your stance on the fact, and that can happen at a lower level. I mean, but briefs are not just reserved for the Supreme Court. But you want to talk about kind of what goes into a brief and what the point of a brief is, because that's a pretty big process sometimes.
It is. It's basically it's what the way I explain it to clients at times is, and it's a little more than this, but it's similar to a written down closing argument, because a lot of people, they watch larger shows on TV, and none of them are accurate, so I don't think they are. But they watch those shows on TV, so they understand what a closing argument is. A brief is basically me writing to the judge, or the other side, the other attorney writing to the judge to explain why we think the judge should rule in our favor. Briefs tend to, and at the appellate level, they have certain requirements that the brief has to have in those, but essentially you set forth what the evidence is, a summary of the factual background in the case. They call it a statement of the case at the appellate levels. And then the legal arguments where you're citing case law and things of that nature, which if you're arguing a closing argument to a jury, you're not going to say, well, in Roe v. Wade, the court said this. You're not going to say that to a jury, but that's what you do in a legal argument to a judge on why the judge should rule in your favor is, in Holman v. Holman, the court said this, and the court should apply that same reasoning to this issue that's being presented today. And so that's kind of what a brief is just making that argument to the court.
And both sides do that, right? And again,
Yes.
it just kind of lays out their position and what they think is most important based on the point at question or in question. Correct. And then that may be part of the reason why it's a 15-minute process, right? Because they've already read the briefs thoroughly. They've already kind of looked at it. They've probably done their own side research to make sure that what you were claiming is actually accurate and factual.
I hope not.
Back to your razzmatazz. No, but I mean, that's kind of the point of it, right? I mean, they spend a lot of time reviewing those briefs, I would imagine.
Yes, and the 15 minutes can also, if they ask you a bunch of questions, they will give you a little bit more time from that. And that's one of the benefits I had of arguing it by Zoom over video conference is I couldn't see they have a timer there in the Supreme Court courtroom that's counting down from, on my initial argument, it would have started at 12 minutes and counted down. I couldn't see that on Zoom because it's not one of the things that's on camera there. So I think I probably actually got a little extra minute or so because my time had run out, but I didn't know it had run out because I couldn't see it. I had a timer going here, but one of the reasons is for the 15 minutes, I think, is in part because of that. They do have the briefs. They've already reviewed those. They know what their questions are going to be before they come in there from that standpoint. And the other part of that is lawyers will keep talking as long as you let us keep talking. So,
especially the hourly ones.
Yeah,
So.
the ones on the hourly rate basis will definitely do that.
Well, so let me ask you this then: if the Supreme Court has the brief, they've seen how all the other courts below them have ruled on it, what is actually the point of having an oral argument? I mean, because everything's already laid out. You've kind of already shown all your cards now. Why an oral argument? And what is that meant to influence them, or are they just kind of tightening up their impression on things?
I think I do believe that the oral argument can be very beneficial to both sides. If they have a question on something, then they can ask that question, and the attorneys on both sides can address it to some extent. In the oral argument I had last week, they asked a question of the opposing attorney, and that attorney had it was the attorney general person that was there had addressed a point, and it was in response to a question. And when I did my rebuttal, one of the first things I did was point out why their argument was incorrect. And it was a point that I had not briefs also have a page limit.
Okay.
And so my rebuttal brief, my reply brief was limited to 10 pages, and I'd raised several issues in this case, constitutional issues. And when you're addressing a constitutional issue, it takes a lot of time and a lot of paper to actually address that. So I addressed the main arguments in my reply brief, but I didn't have time to address everything they had said. And there's one of the things they had argued in their case was, well, the statute in effect on the time, even though it was an unconstitutional statute, it cut off benefits at 2 years. The new statute cuts off benefits at 4 years. So actually, it's a better. They didn't take anything away; they actually increased it. And I got the opportunity to point out to the Supreme Court that the case law has, for a century, longer than a century, has been that a statute that's unconstitutional is unconstitutional from the day it's initiated. It's void, null and void from the beginning. So their argument that the statute said 2 years and now she gets 4 years wasn't accurate, because the statute that said 2 years was unconstitutional in 1996 when it was passed.
Should have been dead on arrival.
It was dead on arrival,
Yeah.
yes. And so their argument was incorrect. I didn't get to make that in my reply brief because I didn't have time, and I assumed, and I think correctly assumed, that the Supreme Court was well aware of that precedent. I know at least one was, because the way the video was set up, I didn't see all 7 justices at one time. There was one justice who I could see at the time I was making that rebuttal, and she nodded her head yes, that she was aware of the case law that I was citing in that rebuttal argument. So it gives you, it was a question that had been posed to them, and I got to expound on it, and I think that, at least I'm hoping that helped convince some of the judges, or at least if they weren't aware of that, they are now aware of that precedent and what that precedent is from that standpoint. So,
I'm always interested to hear the page limit to these arguments. You just don't want to go on forever. But, one thing I learned in high school, and this may help you, Jeff, is if you shorten those margins a little bit, you might get some extra words and maybe reduce the font. Usually in high school, I went the other way. Increase the font, double space, and increase the size of the margin. But if it helps, Jeff, you can take that with you, okay, bud?
The court is already aware of that, so the rules say how wide the margins have to be.
Do they really?
And
Wow.
what font and double space and all of that. Yes, it is. It's spelled out, so you cannot really fudge on those.
Limits the tricks.
To get exceed the page requirements. And in some, because you can have an appendix, and some attorneys have, they had the page limit, and then they said, well, see, appendix 1 for something, and then filed basically 50 more pages of brief as an attachment in the appendix. And the court said, no, you can't do that.
Can't do that either.
You're not allowed to do that. So that's unfortunately, the court system's been around for a long time, and the Supreme Court and the appellate courts have learned our tricks, and they've figured out ways to avoid us being able to pull those off. So.
Right. But ultimately, the point is get to the point.
Yes.
And what's the fact, that you're arguing and why, and we'll make the decision.
That's true. And a lot of times in a written argument, sometimes, depending on how many pages you've got, but if you've got plenty of pages for the number of issues, you start with a strong point, the next strongest point, the next strongest point, and you keep working your way down from that standpoint. And, when you have a number of pages, you just don't, things that really weren't strong points just don't get addressed.
Right,
And
right.
As a general rule, you have time. And most of the courts, if it's really, really something that needs to be addressed, the courts you can file a motion to file a brief in excess of the page limit. And, I do that actually at the administrative law judge level. In cases when you've got a whole lot of witness testimony that's got to be summarized, and the page limits, the higher you are in the appellate process, the greater number of pages you have. So at the workers' comp administrative law judge, you're limited to 15 pages, and 15 pages double spaced. When I was in college and even in law school, seemed like forever to write a 15-page double space. But when you have to summarize the evidence from 10 different witnesses,
Not a lot of room.
then you got 5 pages left or
Yep.
somewhere in that neighborhood to address all the legal issues. And so, it's extremely rare that a judge would not allow a brief in excess from that. Now, if you attach 50 pages as an appendix, courts aren't going to be quite as happy about that.
Right. So let's close with this then. Roughly, so this is the last week of April,
Yes.
and you pretty much wrap this up this week. So when do you expect a decision on the outcome of the case that you argued?
There's no set deadline on the Supreme Court. I would expect to have a decision probably in 3 to 4 months.
Wow, that long.
From that time frame. It may be quicker, but it's not just my case they've got to decide. They've got other cases as well that they're having to decide. They got to digest everything. They've got oral arguments. Last Wednesday when I argued this matter, there were 2 cases that were argued before mine case was, and so how long it will take them to get a decision, I don't know, but I don't look for it until probably August.
Right. Well, Jeff, I wish you the absolute best, and there's a whole bunch of inter-Kentucky workers who are also wishing the best for you because it's going to affect their pockets one way or the other. And it's a pretty important issue.
I agree, and I hope that I've done my best on it. And I hope I've done the injured workers proud, and ultimately will be successful in that. One kind of weird coincidence that I was going to bring up to you is, of course, my oral argument before the Supreme Court was this past Wednesday, which was April 21st. And exactly 1 year prior, April 21st, 2020, was when I was sworn in and served as a special justice to the Kentucky Supreme Court.
We did a blog post about that.
Exactly.
In
a case. So it was, 1 year to the day. Was special justice, and then 1 year, the next year, the exact same day, about the exact same time, I was arguing a different case to the Supreme Court. So I just
Funny how these things work.
I thought it was odd that it was the exact same day, 1 year apart, that I was arguing this case versus when I was the special justice. So
that's fantastic. Jeff, I know you're busy. You got a lot on your plate these days. I really thank you for your time. Thanks for sharing this with the listeners and just kind of giving people some inside views of what really happens at the state Supreme Court level. And this is Kentucky's. It could be different in other states, but this is how we do it here. And I'm talking right now to one of the guys who knows how to get it done up there. So, Jeff, I appreciate it, buddy. Thanks for your time.
Good to see you again, Jim.
Take care. Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.